Welcome to today's video. We're looking at how to quash a criminal charge. As we all know, a criminal charge can be very tedious, very costly, and sometimes emotionally draining for anyone to have to go through the entire process of a criminal charge, particularly where the defendant suspects that he's innocent, he's not done anything, and that for whatever reason the charge has been brought to oppress him. So what can a defendant do when he believes that he's innocent of a charge and he doesn't want to go through the whole rigors of a trial before he can actually get it dismissed or quashed? So we're looking at, that's what we're going to be looking at, how to quash a criminal charge. Don't go away. I will be right back after this short break. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. Yep, so we're looking at how to quash a criminal charge. As we all know, there is already in Nigeria the Administration of Criminal Justice Act 2015, and of course all the children of this parent act in the states. By the children, I mean the reenactment of the acts in the various states of the federation. Not all the states, but most of the states have their own Administration of Criminal Justice law, which is an offshoot of the Administration of Criminal Justice Act. And the act tried to do a couple of things, one of which is to speed up criminal trials. So the act actually tried to remove or stop all kinds of objections before a criminal trial. So it says, you know what, if you have objections to a criminal trial, wait until the end of the case, then you can state your objections and the judge can consider your objections. Now that's good, because then it helps for speedy dispensation of justice without technicalities, stopping the trial, putting a stumbling block on the trial or clogging the wheel of the trial. So the defendant is arraigned, prosecution has their day, defendant has his day, the court decides the case. In deciding the case, now it considers all objections. Now that's good as far as it goes. However, you and I know that Nigeria is not it's not a civilized society, if I might put it like that. I was just going to say it's not a sane society, but I won't say that. Okay, our criminal justice system, powered by the security agencies, are not what it should be. Is that nice enough? I'm not going to knock anyone today, so I'm just going to use my words very in a chosen manner. So it's not what it should be. Most police officers are corrupt. Most security agents are corrupt. Very few really make it their dream to uphold the law, to uphold the moral of the law, to uphold the justice of the law. So the law is usually amenable to the whims and caprices of individuals. Now the drawback of that is that most cases are charged to court in abuse of process of court, just to score either political or whatever points, or just to show that one party is stronger, more weightier than the other party. Okay, I hope I'm choosing my words carefully now. Bottom line is that most criminal prosecutions ought not to go to court because they lack merit. There's no basis for taking them to court. And if you are a lawyer, practicing lawyer, you would have come across several of these. I'm sure most judexes, judges, magistrates, etc. would also have come across this. But the difficulty is that you don't find this out until the accused person is discharged at the end of the day now. I remember a case where a couple, a Christian couple, they were actually reverend. The man is a reverend, the wife is a reverend. They were wrongly accused by their Christian organization, of forging a document wrongly. The matter went through the whole. In fact, they were remanded in prison custody at some point for about 2 weeks. They were in prison. Eventually, at the end of the day, the court found them, not guilty. They didn't do anything wrong. But they spent time in prison. They spent money paying lawyers. They spent money, defending themselves. They lost all kinds of opportunities, spent time in prison, and at the end, the system just says, you're free to go. So, for me, that is not acceptable. I think that our system must have a way to determine, to sieve, if you like that word, cases that really, really ought not to go through the whole hog of a trial. So, so that at the earliest, you can't stop a complainant from complaining. The court can't stop the police from, filing a criminal charge. That's their job. Sometimes they do it right, sometimes they do it wrongly. Most times, in my opinion, they do it wrongly, but that's my opinion, okay? So the only thing that the court can do is to design a system where you can actually, separate the chaff from the grain. You can sieve the cases that are proper, that ought to go to trial, and remove them from those that are filed in abuse of process of court. Okay. Now, the way to do that is what we are looking at. First of all, let's just lay a basis for it. The Administration of Criminal Justice Act 2015. It's a long word, so sometimes one tends to sort of swallow some. Administration of Criminal Justice Act 20. I hope I got it right now. 2015. There are two provisions that I want us to look at, and then we can then talk about obviously how to get around it. Now, first of all, section 2. What is section now? Section 396. 3961. So 3962 says, after the plea has been taken, okay, fair, let's at 3961. The defendant to be tried on an information or charge shall be arraigned in accordance with the provisions of this act relating to the taking of pleas and the procedure on it. So a defendant to be charged, will be arraigned in court, and his plea will be taken. That's what the law says. Then subsection 2. After the plea has been taken, the defendant may raise any objection to the validity of the charge or information at any time before judgment. Okay? All right. After the plea has been taken, I read it again. After the plea has been taken, the defendant may raise any objection to the validity of the charge or information at any time before judgment. So, first you take his plea. Then he can raise his objection to the validity of the charge at any time before judgment. All right? Provided that any such objection shall only be considered with the substantive issues and a ruling thereon made at the time of delivery of judgment. Okay, so what this provides is actually quite simple. The defendant should take his plea. Then, after taking his plea, he has the right, to raise any objection as to the validity of the charge. There's duplicity in the charge. What kind of objections can they raise now? The duplicity, the charge is vague, it's unspecific, blah, 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 whatever. So, the law says you can raise these objections, but these objections shall be considered along with the substantive issues, and a ruling will be delivered thereon at the time of the delivery of judgment. So, that's understood. Now, let's look at section 396, subsection 2, if you have the federal one. Then, section 220. 221. Sorry, sometimes I mix up the section. 221 says, objections shall not be taken or entertained during proceeding or trial on the ground of an imperfect or erroneous charge. I can take it again. Objection shall not be taken or entertained during proceeding or trial on the ground of an imperfect or erroneous charge. So you have these two provisions, section 396 subsection 2, and then you have section 221, which says you can take your objections after plea, and then the court will determine it at the end of the trial. So you have to go through the whole trial, okay? And of course, you know that I won't like such a thing, because if the person is innocent, why should he go through the whole trial? So that's how the law now came up with the principle to quash a charge on the ground of jurisdiction. Okay, so that's a way out. If you're facing a charge and you know that the charge is useless, it's incompetent. Perhaps, for example, it's a civil dispute and some crooked security agent, some crooked police officer just fires a charge, just to score a political point or to fulfill the dream of his master. This is how you can, actually truncate that charge. And the procedure is, as I've said earlier, by filing a preliminary objection relating to the jurisdiction of the court. Now, I think all lawyers will understand that there are three ambits to jurisdiction of a court. There are three sides to it. The first side is that the subject matter of the case must be within the powers of the court. That's one side. The second one is that the court, the presiding officer of the court must be competent, must have been properly appointed, and there is no defect in his appointment. That's the second one. And then the third one is that the procedure for initiation of the case must have been followed. Okay? So you look at the subject matter jurisdiction, you look at the positional jurisdiction of the court, then you look at the procedural jurisdiction. So now, where you feel that there is a defect in the procedural jurisdiction of the court, in other words, either the proper procedure for initiating that charge was not followed, or the subject matter is not within the jurisdiction of the court, you have a right to challenge jurisdiction. For example, civil matters. I think this is one that really comes to mind. There is some argument over land dispute, and the one party who feels is powerful tries to resolve it by resort to criminal prosecution. So he gets the police to arrest the other guy, and then they charge him to court, thinking that, if we charge him to court, he's going to be intimidated, and ultimately he will abandon the case. Now, there are obviously two streams of argument on this point, and I want to address them at this point, the two streams of argument. The first stream of argument is that some judges will tell you, no, you cannot raise you can raise your preliminary objection, you can argue them, but I will take a decision at the end of the case, in accordance with section 396 subsection 2 of the AJA, the Administration of Criminal Justice Act. That's what some judges will say. Raise your objection. You are entitled to raise your objection. The law says you can raise your objection after plea, but I will only take a decision on it at the end of the case. So you go through the whole trial. The second arm of it is that some people feel once issue of jurisdiction is raised, the court has no competence to do any other thing except first to resolve that issue of jurisdiction. Now, this whole, potpourri of arguments, came up in a recent case, which was decided by the Court of Appeal in Nigeria, Kaduna Judicial Division, before their lordships, Masood Abdurrahman Oredola, Justice of the Court of Appeal, Ibrahim Shatta Dilia, Justice of the Court of Appeal, and Oludotun Adebola Adefokpe Okoje, Justice of the Court of Appeal. So these are the three justices of the Court of Appeal who delivered this judgment on the Tuesday, the 5th of February, 2019. Okay, the case was between Ibrahim Shehu Shema and Federal Republic of Nigeria. I'm sure you know Ibrahim Shehu Shema. He was one of the governors of one of those states. Katsina State, I think. He was now taken to court after his tenure as a governor, as we are used to in Nigeria. After governors finish their tenures, while they are doing their tenures, they embezzle all the money, and then after their tenures, we have to fight to get some of the money back. But okay, so I'm not being prejudicial now. If you are a governor and you are not embezzling, kudos to you. But if you are a governor and you are embezzling, well, you are waiting for your time. One day you'll be in jail like some governors. At the point I'm making this video, former governor of Taraba State, Jolly Nyame, I think he was former governor of Taraba State. Well, I'm looking at the producer looking at me. Former governor of Taraba State, I think he was Taraba State, Jolly Nyame. Okay, if I'm wrong, whatever state he was, one of the former governors. Supreme Court affirmed a sentence of 12 years imprisonment for corruption, embezzlement. Okay, and then we have some others at this point who are in jail. Ojus Okalo is serving, I think, about 12 or 14 years, sentenced by the Federal High Court in Lagos. Who was there? Two or three others, some of them. So, it's not celebratory, it's not salutary, it's not something that we can be proud of. That our former governors, once they leave office, they have to go to prison. Dele Igbinedion of Edo State had to forfeit some money to run, to escape going to prison. And so on. And James Ibori, popular one who Nigerian court could not sentence, but the English court sentenced him to several years imprisonment. So the list goes on and on. Anyway, Ibrahim Shehu Shema was one of those judges, one of those former governors, after his tenure, he was charged to court for embezzlement of funds from the accounts of the Katsina State government. Now, while he was charged to court, he took his plea and then filed a preliminary objection to the competence of the court to entertain the charge. So he was saying, look, this court, you don't have competence to entertain this charge. You need to strike it out or quash the charge. The judge, I'll give you the name of the judge for those of you who are interested in it, students of law. Can get it in a minute. What is the name of this judge? My lord. Okay, so it's always good for us to get this, so we can give credit to where credit is due. Where is it? Ah, yes. Honorable Justice B.G. Ashiga. Honorable Justice B.G. Ashiga. So, Honorable B.G. Ashiga, wasn't having it. He said, look, you have your preliminary objection. I've heard you. I'm good to hear you. Move it, but I will deliver my ruling at the end of the case, pursuant to section 3962 of the AJA. The lawyer for Mr. Shehu Shema, J.B. Dauda, senior advocate of Nigeria, one of our brightest legal minds in the legal profession, took this matter to the Court of Appeal. His argument was simple. Once the issue of jurisdiction is raised against a court hearing a matter, the only thing the court can do, and the only thing the court must do, and the only thing the court should do, is to determine that issue of jurisdiction and rule on whether it has jurisdiction or not. So that's it. And you cannot delay a jurisdictional ruling till the end of a matter. So until you resolve your jurisdictional issue, you cannot do any other thing. So that was J.B. Dauda's argument. So the matter went to the Court of Appeal. J.B. Dauda settled the brief of the appellant, and the St. Ologunorisha, SAN, another bright legal mind, settled the brief on the other side. So you had these two, legal gladiators, fighting over this thing. Now, so the issue was, does section 3962, which requires that all objections should be delayed, ruling on the objection should be delayed till the end of the case. Does it apply to preliminary objections challenging jurisdiction or not? So that was the issue. Court of Appeal distilled that sole issue for determination. Okay, so I hope this is not too complex. If you are not a lawyer and it's complex, leave your comment on the comment section and someone will help you clarify anything you don't understand. Okay, so that was the point between these two, legal gladiators, to determine so they argued, quite vociferously, as lawyers are wont to argue, with a lot of sweat and brigandage, not brigandage, a lot of braggadocio, I wanted to say. All right. At the end, this was the decision of the Court of Appeal. Okay. Now, the court said that they referred to the case of Nanle versus Federal Republic of Nigeria, where they said, by the interpretation rule, where a specific thing is mentioned, another is excluded. In this respect, Section 3962 of the AJA requires a court where objection to the charge is raised to defer decision on it until the end of the substantive case. But in criminal matters, where the objection is not to the charge or information, but to the jurisdiction of the court in some other way, then the court has discretion when to decide it. But the prevailing view is that it should be at the earliest stage. So they looked at this authority and they decided as follows. In summary, this is what the judge said. I'm of the firm viewpoint that Section 221 and 3962 do not cover other grounds of objections outside those predicated on the charge or information with which an accused was arraigned. Thus, where the objection is predicated on other grounds outside that enclosure, particularly on the jurisdiction of the court, as in the instant case, the established position of the law is that such objection predicated on jurisdiction should be heard and determined timeously and or at the earliest time, which is usually when it was raised. I am of the firm viewpoint, he went on to say, that where an applicant invariably contends that a proceeding or action is discredited or tainted with coloration that impinges or touches on the jurisdiction of the court, then a jurisdictional issue or point has been duly raised. Put differently, when an applicant contends that there is an aspect or feature in a case which borders on or is capable of preventing the said court from exercising its vested jurisdiction, then a jurisdictional issue has been agitated or raised, and the court will have to determine one way or the other whether it has requisite jurisdiction to hear and determine the case or matter. So that's what the court decided. My Lord Justice Masood Abdurrahman Oredola, Justice Court of Appeal. So the two other justices agreed with him. So obviously, that is the point, that where a jurisdictional issue is raised, the court must decide it first. Consequently, the court does not have to wait until the end of the case. See? Yes, I know that some people will see this as kind of tedious law, but hey, if you are a practicing lawyer, this is important for you. This decision of the Court of Appeal, Ibrahim Shehu Sherman and Federal Republic of Nigeria, you see the prevailing law, because at this point, yes, this case I think it has gone to the Supreme Court for final decision, but until the Supreme Court decides otherwise, this remains the law. I'm going to take a short break and I'll be right back. If you have not subscribed to our YouTube channel, Pinnacle TV YouTube channel, please do subscribe. Click the notification bell so that you get all the videos that we upload sent to you automatically, and then give us a thumbs up and share the video so that your friends can look at it. So I'll be right back. I'll take a short break and I'll come back. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. Okay, so now that is how you can quash a criminal charge. Once you find out that the criminal charge was brought mala fide, that's a big word, was brought maliciously, The court has no jurisdiction to entertain it. It's a civil matter. Essential ingredients of the charge has not been postulated or put forward. Anything you think comes up that robs the court of jurisdiction, you ought to bring that application and get the charge quashed. The court will quash the charge, and then you can walk home free. You can walk home free of charge. You don't have to wait until the end of the case. Okay, so this requires some legal engineering, some legal tailoring, some legal mechanics, whatever you want to call it, to be able to distinguish between, those cases where the court has no jurisdiction, and you can successfully actually use this preemptive strike, if you call it that, preemptive strike, against the prosecution, and others. So I encourage, if you don't have a copy of the judgment and you want a copy of it, you can of course leave us a message or DM us, and we can send you an electronic copy which you can print out. So that's it. The chambers of JB Dauda SAN were kind enough to have sent us an electronic copy upon our request, so we can also oblige you with it. The reason of the court is extensive, very detailed and very beautiful, and I think that everyone should be able to read through this judgment, particularly if you are a stakeholder in legal jurisprudence in Nigeria, so that you can also make up your mind about these things. Right? And now, if you have any comments, questions, inquiries, or you just don't agree with us, or you agree with whatever we have said, leave a comment for us. Either way, I'm good with it. See you in the next video. Bye-bye. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.